Well, Mr. Yip, of course, you were one of the past presidents of our Law Society, and well, in order for our audience to know more about you, let's talk about more of the background of why you pursue a career in law in the first place, and we can go through your career development in the years.
Okay. Well, it wasn't a boyhood dream or ambition to be a lawyer. Frankly, I didn't know what I wanted to do. But after I graduated from high school, one of my classmates went into the law, and he said to me, "This is really quite fun." So I said, "Why is it fun?" He said, "Well, you get to do a lot of outdoor work." So I said, "Well, you know, doing lawyer's work should be desk work, indoor work. Surely, why is it so much outdoor work?" He said, "Well, yes, well, the first year when you join the law firm as a 5-year article clerk, in your first year, you go running around to everywhere, to the law courts, to the registries, to serving writs, all the things that what our litigation clerks now do. In those days, for the first year of our 5-year articles, we have to go and do all that work and learn how that work is done. So we have to learn from right at the bottom. So I said, well, that's quite fun, because I used to like it, the outdoor life. So I said, well, let me give it a try. So that's how it all started.
I see. So back in the days, it was 5 years article training, what we call the trainees these days. Of course, as opposed to our 2-year training now. And you did mention about running to the courts, doing all the filing work, even issuing writs of summons. That would be very interesting because for us lawyers in this generation,
you wouldn't know how to do it.
Right? Well, we don't know how to do it, to be honest. Yeah. Apart from asking our very friendly clerks, to can you just go to the court for us? Yeah, that's very interesting. So, well, throughout your 30-40 years career, what aspects of being a lawyer which you find most fulfilling and satisfactory?
Well, I think there are two aspects to this. The one aspect is, I suppose, really the more ability to solve problems. The philosophical aspect of it is that you actually, you're solving a problem for somebody. You're finding a solution to a problem, and you're helping them to find closure to an issue that is bothering them. So particularly in litigation, you do find most of the time some sort of closure, either it be a trial in the courts or it be a settlement of the claim. So you have to find a solution. I think this is really what we are. As lawyers, we have to find solutions. And more so, I think, in litigation than almost anything else, because you are really trying to solve a immediate and perhaps an anxious issue for the client. The other thing is, of course, I enjoy the cut and thrust of litigation, the deployment of strategies and tactics in order to produce a result that is beneficial to your client. So there are two aspects to this, and I think these are the two areas that were most satisfactory to me, gratifying to me as a lawyer.
I see. So, of course, we know that you have been a senior partner in JSM. Of course, now it's called Mayer Brown. Being one of the oldest and largest firm in Asia, well, can you share more about your experience and your practice in the JSM days?
Yeah, sure. I qualified in 1971. I did my training articles in London. I came back and I was employed by Johnson Stokes & Master. And from 1972 to 1977, I was an assistant solicitor. In 1977, I became an income partner. And 2 years after that, I became an equity partner. All through my life, my professional career, from the day I was qualified until the day I retired in 2004, I was a litigator. So I was the most junior litigator back in 1972, and I became the senior partner of the litigation department, and then I became senior partner of the firm. So 32 years, man and boy, only one job.
In the same firm as well.
In the same firm. So that was basically what I did, and it was a wonderful firm to work for, particularly to learn the skills of litigation, because I think we probably had the biggest litigation department in Hong Kong at the time, with the possible exception of Deacon's, which also had a very large litigation practice. And we did almost every kind of litigation you can imagine. And in the early 70s, when I first came back to Hong Kong, we even did some crime. And we did some legal aid work, and that involved sometimes serious crimes like robberies and even a murder. I was given a murder case to do within the first 2 years of my working in JSM.
In JSM?
Yeah, there was a legal aid
Hardcore
case,
crime.
legal aid case, hardcore crime.
I see.
And we had all kinds of course, civil work. We were the lawyers at that time, the exclusive lawyers for HSBC. And so we did a lot of banking-related litigation that would range from loan enforcement to mortgage enforcement to all kinds of liquidations and restructuring and all that. So everything you can think of in banking litigation. We had a very big insurance practice, a lot of very big marine insurance practice. We acted for the two major bus companies of the day, China Motor Bus and Kowloon Motor Bus, and we acted for a number of the major insurance companies. So we had a very stable bread and butter type of litigation practice, on top of which we had all the civil disputes that you now see, for example, corporate disputes, shareholder disputes, minority shareholders, disputes with companies, and so on and so forth. So it was extremely rewarding and gratifying. We also started, back in the early 70s, the practice which grew into now quite a major practice all around Hong Kong, medical legal practice. And back in those days, there were the two major worldwide organizations, the Medical Defense Union and the Medical Protection Society. They were both our clients. They set up in Hong Kong and engaged us as their exclusive lawyers at the time. So we built up a fairly sizable medical legal practice over the years. So, you know, it was a very interesting experience for me as a young solicitor, and the firm and the litigation department grew over the years, and it remains, I gather, still one of the major practices of the firm now.
So, Mr. Ip, well, you were one of our past presidents back in '87 to '89. So, can you share with us more about your experience back then, your achievements, and of course, some of the challenges which you most memorable to you back in the times?
Right. I became vice president in 1985 until 1987, and then I became president from 1987 to 1989. Now, that was a very momentous period in Hong Kong's history, because in 1984, there was the signing of the British-Sino Joint Declaration. And the years after that, right up until the 1990s, and the handover in 1997, was a period of great uncertainty in Hong Kong, and a period of anxiety and almost despair to some people, because it was very uncertain what's going to happen during the transitional period, and that resulted in many people emigrating. And there was this huge brain drain from the legal profession as well to other common law jurisdictions. So to become involved as vice president and then president of the Law Society at that time was a very challenging period, and had many difficult tasks that we had to perform. Some of these things would be, for example, the drafting of the Basic Law, the process that was started in the mid-80s and completed in 1990 when the Basic Law was enacted. I was a member of the Basic Law Consultative Committee, and I was also, during that time, vice president and president of the Law Society, and I set up a working party of the Law Society to consider the many drafts that came out from the drafting committee. And not only did we consult our own members, but we also expressed our views in the public and then consulted the public as well. More particularly the other professions, because we knew that those professions would also be very concerned about, for example, the future regulation of the professions, the ability to self-regulate. These were the issues that they were very concerned about. And I remember we led some delegations to Beijing to talk to the drafters, to express our views and our concerns about, in particular, the differences that we were able to spot between the provisions of the Joint Declaration on the one hand and the draft Basic Law on the other. And I'm glad to say that a lot of our points were taken on board and the drafts were amended, and finally the Basic Law that was enacted reflected the views that we expressed. We also went to London to see parliamentarians, to see the people who were responsible for seeing there would be a smooth transition, etc., of Hong Kong. So we expressed our views to them as well. So that was a very major exercise during that whole period. Another very challenging thing was that concerned the profession more than the community as such, was the foreign lawyer issue. Back in 1988, the government announced that at the request of some US law firms, that the Hong Kong government would allow US law firms to set up practice in Hong Kong as Hong Kong lawyers simply by employing Hong Kong lawyers or by taking into partnership Hong Kong lawyers without themselves being qualified to practice Hong Kong law. Now, that announcement took everybody by surprise because prior to that announcement, the government or the governor of the day appointed a working group to consider that particular issue. That working group was chaired by the CJ, Sir Dennis Roberts, and I was a member of it. And a representative of the bar was a member of it, and others interested parties were also represented. And the working group agreed with the Law Society's position. In fact, it was hard to imagine that anybody could not agree with that conclusion, because how can you practice Hong Kong law if you're not a qualified Hong Kong lawyer? Simply by employing a Hong Kong lawyer, and then you can now then practice Hong Kong law completely. And so when the government made the announcement overruling the CJ's working group, we made further representations to the government, but they were very steadfast. They said, we have to do this because this will be very good for Hong Kong, good for Hong Kong's status as a international commercial center. We should have all sorts of foreign lawyers practicing Hong Kong. Effectively, it's a free-for-all. So there began a very drawn-out, very acrimonious battle between the legal profession. The bar joined in to oppose the proposal, and we enlisted the help of 8 other professions, because they were in the same boat as we were. I mean, how could I practice architecture if I'm not a qualified architect, simply because I employ an architect? It was not, no, it didn't make any sense to professional people. So it went on for quite a while. We went to the public, we went to IXCO, LegCo, we explained the position, and we got a lot of sympathy. And then in 1990, the government decided to withdraw the proposal. So effectively we won the battle. But the profession and the government continued afterwards to explore a proper system of accreditation or exemption, whereby foreign lawyers could qualify as Hong Kong lawyers, Hong Kong solicitors, to practice Hong Kong law. And in 1994, finally there was a structure, framework, agreed, which is the structure that now exists.
The
which,
OLQE structure.
Yeah, which requires a foreign lawyer either to take examinations or get accredited with regard to certain qualifications and have associations with local law firms, etc., for a period. And in order that they can become more familiar with Hong Kong practice, Hong Kong law, etc., and then they can set up shop and practice as Hong Kong lawyers. So the system that exists now was started back in 1994 when legislation was passed to give effect to this framework. But during 1988 to 1994, there was a lot of disagreement with the government over that.
It was a long battle.
In particular, between 88 and 90, when the government withdrew the proposal.
I see.
So that was a very major issue that occupied a lot of my time and a lot of the time of the council of the day.
I see. It was such a long battle indeed.
It was a long battle.
And well, how it now transpires our OLQE system as well. Yeah, and well, in which case, how did you manage the expectation of profession back then, having such a long battle? Of course, I mean, I can imagine a lot of our members would have already voiced out.
They were up in arms. I mean, the profession was very, very upset with the government, the very high-handed way the government behaved, and overruling effectively the recommendations of the Chief Justice's working group. So it was something which was unprecedented. Within a couple of months of my presidency, we received an invitation from the Ministry of Justice via the All China Lawyers Association in China to visit China for an exchange trip. The purpose of that visit was expressed to be to promote good relations between lawyers of Hong Kong and lawyers of the mainland, and for them to learn more about the common law system of Hong Kong and for us to learn more about their system, which we regarded then, of course, as being very important, because it is only through a proper understanding of and a respect for each other's systems that we can truly make one country's two systems work. So we readily accepted that invitation, and it was arranged by Xinhua News Agency. And in November, a few members of the council went on our trip. That trip was hosted, as I said, by the All China Lawyers Association. We spent 6 days in Beijing, 3 days in Xi'an, and 2 days in Guangzhou. On the first night of our visit, we were hosted by the Minister of Justice, Mr. Zhou Yu. And the next day, we went to the Hong Kong Macau office, and we met Ji Pangfei, Gei Pangfei, Ju and Fu Ju Lo Ping, Xin Sang. So we were given a royal treatment, and apart from the expenses we paid for our trip to Beijing and back to Hong Kong, all those expenses were paid for by our hosts. We visited the Legislative Affairs Commission of the National People's Congress. We met with the director there, He gave us a very full description of the legislative program they had in mind, and they impressed upon us the importance of having a functioning legal system to underpin the country's future economic and social development. That visit that we paid to the mainland was of particular historic significance because it was the first time in the history of the People's Republic of China that the Law Society was invited officially to pay a visit there. That laid the foundations, I believe, for the good relations that have been enjoyed by Hong Kong Law Society and the All China's Law Association through these 30-odd years of joint efforts. We spent 11 days on the mainland, which were basically a very well spent 11 days, learning more about their system. And in 1987, the China we knew then is very different from the China we know now. And so naturally, there was a lot to learn as to what was going on there at the time. And there was a huge amount that they needed to learn also about what was happening in Hong Kong and also what's happening in the outside world. So it was a pioneering trip, which was very important. And I think also we discussed the setting up of an office under the Ministry of Justice that would help Hong Kong lawyers to have access to mainland law and mainland lawyers. So that was the beginning of the setting up of the All China Legal Services Limited. They had planned to do that anyway in 1987. When we were there, we discussed about the technicalities for them to set up the organization. And shortly after our trip, we helped them to set it up. And that organization continues to exist today, as you know. And that was the very beginning of the relationship between the Law Society and the China Legal Services Limited, as well as the All China Lawyers Association, and of course the Ministry of Justice. So I think that was really the kind of the first major official step to start the whole relationship that we now take for granted in many ways. That's part and part of our current legal system. Well, the Basic Law Drafting Committee was set up shortly after 1984. Consultative Committee was set up, I think it was in 1986. I was appointed to the Consultative Committee in 1987, and I arranged for a working party of the Law Society to be set up to study the various drafts that were coming out from the Drafting Committee. We did a lot of work on the drafting of the Basic Law. We went to the mainland, to Beijing, to speak to a lot of the drafters with our views. And we also went to London on a number of occasions also to express our views to the British government. And ultimately, in 1990, of course, the Basic Law was promulgated, and to a very large extent, the comments that we made were accepted. We made a lot of comments, not only on the constitutional aspects of the Basic Law, but in particular on those parts of it which affected the professions, in particular the legal profession, the judiciary, and everything else to do with the legal system.
Of course, during your 30-40 years career, a legal career, you were also a electrical member. Mm-hmm. So managing a big firm, one of the largest firms in Hong Kong and Asia, and being an electrical member at the same time, what sort of challenges did you have back then? How did you manage them?
I couldn't really carry on a practice when I was in LegCo between 1991 and 95. I had to take leave, as it were, from the firm because it was a full-time job in LegCo, and it just simply was not possible. And at that time, I almost retired from the firm because I said to my partners at the time that it was, I think, unfair on the partners for me to be employed or engaged, shall I say, full-time on some other occupation.
Okay.
But I was asked not to leave, not to retire, but I was asked if I could remain in a managerial management role, just to continue to sit on our management committee, which I was able to do. So for those 4 years, I really wasn't doing any client work. It wasn't until I left LegCo in '95 that I continued with my management role. Then I became senior partner
I see.
from 1996 onwards till I retired in 2004. But it wasn't not possible really to try and combine the two functions. It was just too much.
I see. But still, you stayed with JSM as one of the management committee's members, right?
I stayed on.
A managerial role.
Correct.
Yeah, but still, that would have taken up so much of your time, and of course, having a busy LegCo practice as well.
It wasn't so busy sitting on the management committee. We would meet maybe once a week, and then it was really very much a discussion, decision-making body as opposed to an executive body.
Okay.
At least my role at the time was not executive. So I devoted most of my time, if not all of my time actually, to LegCo during those 4 years.
Well, being the only solicitor who took up the LegCo office in the early 90s, what drew you to this office, or what motivated you to be a LegCo member serving in the legal constituency?
Yes. Well, what happened was simply that after 4 years of my being involved with the Law Society Council as Vice President and President, I finished my term of presidency in May of 1989. Then June 4th happened. And then between June 4th, 1989 and 1991, that was a period Hong Kong was going through a very difficult time. There was a sense of despair, and there was a great number of people emigrating. And I felt that Hong Kong at that time was actually going through a period of paralysis, both in terms of governance as well as within the community. Things were very uncertain. So I thought I would like to continue to do some work which would help in some way for people to regain confidence and hope. And then I knew that in 1991, the legal functional constituency seat would be vacated by Martin Lee, because he would want to run in the first geographical constituency election that was introduced in 1991. So the legal functional constituency seat became available. And I thought that I could make a contribution. I could help, hopefully, to deal with transitional issues, make the transition smooth and orderly, and basically just try and do my bit. And so I spoke to a number of people, and I decided that I would run. I had got sufficient experience. I had had the exposure over the 4 years when I was president and vice president, and I thought that I would be qualified to represent the profession and to do something for the public good. So that's why I ran.
What was the major issue of facing our legal profession at the time when you were a LegCo member?
The main issue, as soon as I was elected to LegCo, 1991, was the composition of the Court of Final Appeal. Now, the basic law has a provision which says that the Court of Final Appeal may, on its own, decide when to appoint overseas judges and how to appoint overseas judges. The Joint Liaison Group came up with an agreement in 1991 to the effect that in future the Court of Appeal may only invite and appoint one overseas judge to sit on the Court of Final Appeal. Now, that agreement was considered in LegCo. There was a motion debate in LegCo, which I initiated on behalf of the legal profession, to say that the agreement of the JLG was too restrictive, in light especially of the more general wording of the basic law. And we asked that the agreement be reconsidered. That motion was passed by a vast majority, and we asked the government, Hong Kong government, and the British government, and indeed the Chinese government, at separate meetings, if they would reconsider our views. And we put forward some very cogent reasons why we think that we should not be restricted in how we appoint and how many we appoint when the Court of Final Appeal is eventually set up. However, the point was obviously one which was controversial, and neither the British government nor the Chinese government was willing to give way on it. And after 2 or 3 years of continuing debate, finally I, for one, accepted that it would be better to set up the court in 1997, on the 1st of July, in accordance with the JLG agreement, rather than to reject the agreement and not have a court at all, because that would lead us into great uncertainties. Now, that issue continued to be very controversial because many of my colleagues in LegCo at the time did not agree with that approach. They would rather either see the court not set up at all, or that we should pass legislation to allow the court to appoint as many as the court thought necessary or desirable. So that was a very major contentious issue, and so it went to the vote eventually, and the majority voted in favor of setting up the court in 1997, 1st of July, and legislation was passed to that effect a few months before.
In your 30-40 years career, there has been many big changes in Hong Kong and especially in our legal market as well. What are the few biggest changes have you seen so far?
Obviously, there are changes from time to time. The practice of law becomes more competitive. People seem to work very much longer hours than they ever did in the past. And I don't quite understand why it is necessary to work 18 hours a day.
That's pretty much a norm nowadays.
Yes. No.
Yeah. Well, back in your times, I think overtime is kind of like a new creature. It was kind of like a new creature, was it?
What?
Overtime, OT.
No, it wasn't. It wasn't. But what I'm saying is that I now hear that people work these insane hours.
Yes, indeed.
And we never worked those insane hours. We worked hard, but we also played hard. We had time to play as well. We used to work officially had to work on Saturday mornings. We never had long weekends when I was a
before
young
the
lawyer.
5-day work
Right?
week,
So we had to work Saturday mornings, and very often we stay Saturday afternoons as well. And so we had 1 day off a week, but we never had to lose a lot of sleep, like a lot of young lawyers now seem to have to.
I see.
And then they tell me that they have to work 16, 18 hours. Occasionally, perhaps, everybody understands that you do have to do something that is very urgent, very pressing. Tomorrow morning you're in court, and the judges aren't going to wait. So I understand that, but persistently having to work those insane hours seems to me to be counterproductive. And I've always taken the position that, frankly, if you have to work those long hours persistently, then you better watch out about your insurance policy, because you're going to be paying your insurance more money, more premium eventually, because mistakes will be made. It's not possible for people to work 18 hours a day and to be deprived of sleep, for days and days and days. And it's also extremely unhealthy for you not to have time to pursue your hobbies, to get some relaxation,
Indeed. So,
and to refresh yourself.
so what are your advices for our next generation lawyers in this regard?
Well, change the practice, work less. And I think lots of people actually want to have a much more balanced life these days, work-life balance. And a lot of people, maybe for the first few years, they will work these very long, insane hours because they want to learn, they want to get established, and they want to get well paid. But once I think you've had that for a number of years, it is simply unsustainable to carry on working like that, in my opinion.
If there's one thing you can take, what you would like people outside Hong Kong to know about our profession, what would that be? How would you promote?
Well, perhaps not only just about our profession, but I would like people in Hong Kong as well as outside Hong Kong to spend a bit of time to listen to people who can give them genuine views about the state of the rule of law in Hong Kong and the quality and independence of our judiciary and the quality and independence of our legal profession. Because in the last 2 or 3 years in particular, there have been very misinformed, misguided comments, particularly by the foreign press, about pressures being applied to our judiciary and to our lawyers, to certain proceedings being taken for political reasons, and that somehow the quality and independence of our judiciary are being compromised because of the political situation. And I think that those comments are doing Hong Kong a grave disservice. And in my opinion, I don't think that's true. I don't think that what has been said is true.
What are the qualities that you think a leader should have in terms of course, persuading people from different backgrounds, or to convince them to accept your views? For example, what would charisma be one of the essential qualities? So some advice for our younger lawyers.
I think charisma helps. It helps to draw attention to yourself, but that's very superficial. And what you really need, I think, to be a leader is, first of all, you have to learn to listen. You have to listen to what people say carefully, and you have to empathize with what they want. And you have to put yourself in their position and understand their feelings. You have to be a very incisive thinker. You need to know what are the issues involved, and you need to sift through sometimes very complex issues in order to decide what are the relevant issues. And then you try to deal with those issues, and you have to explain those issues to people who you want to bring on board. And then you need to explain, and not just explain, but ask them how they feel about your possible solutions to these issues. I think those are really the most important things, because you cannot know everything. I mean, we are supposed to be experts on the law. People come to ask us about the law. We tell them about the law. We solve their problems. But outside the law, we are perhaps observers. Some of us are perhaps more learned, more erudite on other subjects than others. But you can't know everything. And I think another thing which is terribly important to be a leader is you have to have the mindset that if you are a leader, you are in a position not to rule, but you have the privilege to serve. In other words, although I, in quotes, I lead you, but I'm here to serve you. I'm not here, I don't have the power to rule you. To serve you, I need to understand you. I need to know what your problems are. I need to solve your problems. Anyway, it's like you paying me money as a lawyer. I'm here to serve you, right? And you believe in me because I understand your problems. I explain to you that I understand your problems, and I give you my solutions and explain to you how those solutions would help you.
I'm already drawn into your analysis, so I can totally see the charisma in your leadership already. So, Mr. Ip, thank you very much for your time today. A lot of takeaways for our younger generation lawyers, and of course for our audience as well. And thank you for your time again.
My pleasure.